Let's start off with an analysis of the hearsay rule. Now to get there, you can get there a couple different ways. You can go there by just hitting the rule button and then going to Rule 801, or you can go to the search button and type in the term hearsay and then pick from the options available to get right to the hearsay rule and to do an analysis. So let's go to the hearsay rule and begin an analysis. The first thing you always have to do is think about the definition of hearsay. It's a two-pronged definition. First, it has to be a statement. If it's not a statement, then it's not hearsay. Now, there are three types of statements that can occur. First is a person's oral statement. Second, a person's written statement. And third, a statement of nonverbal conduct of the declarant if it's meant to be an assertion. So those are the three different types of statements you can have. Notice that in the green section, that information that is generated by a device is not a statement and is therefore not hearsay by definition, and therefore would be admissible if otherwise relevant. Information generated by a machine is not a statement by a human being. Another example would be a parrot talking is not a statement by a human being. In the blue, you'll see practice tips. And this practice tip states that statements by a person do not include recordings by machines. For example, a timestamp on a photograph. So let's assume, for the sake of proceeding through here, that you do have a statement made by a human. The next question that you always ask yourself is, one, are you trying to prove the truth of the matter asserted? If not, then it's not hearsay. If it is for the truth of the matter asserted, then you will have to go through an analysis to determine if the statement is an exception to the hearsay or show that it is otherwise not hearsay by definition, and we'll cover that later. So let's go with no at this point, that it's not for the truth of the matter asserted. The app then gives you 9 different reasons why the statement is not for the truth of the matter asserted, but is still relevant. The first is proving the declarant or someone else has knowledge of the statement itself or is put on notice of the statement. Next would be the effect upon the listener. In other words, why did the police officer go to the scene of the accident? Next would be evidence of association. That again would be evidence to show an association with a group or conspiracy, not for the truth of the matter asserted. Next would be state of mind. In other words, the person was angry or upset. You're using the statement to show that sort of emotion, not for the truth of the matter asserted. Background or context. Once again, an example of where a question is asked of a witness and the witness answers yes. You need to introduce the question to put context to the answer yes. That would be, again, not for the truth of the matter asserted. A command is not a proof of the truth of the matter asserted. It's merely a command, such as shut the door. Declaration. Declaration does not contain a fact capable of being proven, so therefore it would not be for the truth of the matter asserted. Something other than for the truth of the matter asserted. If you have a reason for the relevancy of a statement that is other than for the truth of the matter asserted, then it would not be hearsay by definition. A prior inconsistent statement to impeach the declarant's credibility. Prior inconsistent statements are hearsay, unless, of course, they're under oath and sworn to in a hearing. However, generally speaking, the prior inconsistent statements are, in fact, out-of-court statements, but you're offering it not for the proof of the truth of the matter of the inconsistent statement, but to show that the witness is a liar or is mistaken or confused. So that's an example of 9 categories of evidence that would come in for something other than the truth of the matter asserted. Now, if you can't fit it into one of these categories, then you must then qualify the statement as an exception to the hearsay rule or hearsay by definition, not hearsay by definition. And we'll go over that in the next session. A few practice points. Courts will be inclined to give a jury limiting instruction if requested. The limiting instruction would be to instruct the jury not to consider the statement for the truth of the matter asserted, but for, in fact, the other purpose. Next up, we'll go further into the hearsay rule to determine if the hearsay is admissible as an admission by party opponent.